All right. Well, good afternoon, everybody. I'm pleased to conduct this second panel on a topic that has been near and dear to my heart for a long time, dual-class stock and founder control. Ken Bertsch and David Berger of Wilson Sonsini, Ken of the Council of Institutional Investors, have been on opposite sides of the issue of whether public companies ought to be permitted to have dual-class stock structures. They've testified before organizations such as the SEC Advisory Committee, and they've both written influential papers on the subject. Caroline Cherkassky of Stubbs, Alderton, and Markiles, and Chris Shoff of Latham and Watkins both have extensive experience representing startups here in Silicon Beach and Los Angeles generally. Their very impressive bios are detailed in the handout that you all received, and so I think we'll just jump right into the discussion. Let's start, folks, at the venture capital stage, and at least initially, I think this question goes more for Caroline and Chris. Is it true that private investors, venture capitalists, angel investors, and so on, seem to be more willing to give founders control, while public investors have been more resistant? In general, in your experience, how do private investors in the pre-IPO stage view dual-class stock, founder control, and in what circumstances are founders required to give up control as they receive funding? Caroline, you want to start?
Sure. So I actually think it's really rare these days still to see dual-class stock in early-stage private companies. The only times I tend to see it are when we have, for instance, successful founders who are post-exit on their second company. They have a lot of leverage, and that's really the key word for dual-class stock, is if you have leverage to ask for something like that. But there are other places you can get control. So I do think it's still common that founders have control in early-stage companies, but they have it in ways that are got by still hanging on to a majority of the stock in the company. Potentially, the VC funders tend to prefer to get their veto rights, and they have to have the protective provisions that the company can't be sold, can't be funded without their consent, but the founders still retain also a right to consent to those matters.
Yeah, I agree with that. The way to think about control at the early stage, I mean, if you take a step back, the founders, when they form the company, they need to think about who's going to control the company if there's multiple founders. And one thing we like to counsel the companies to implement is vesting on the shares. Because if, while everybody's the best of friends, usually at the beginning, even if it's their brother, their dad, their best friend from college, their roommate, and they say, we don't need vesting on our shares. Oftentimes, life circumstances change. Somebody gets married, somebody wants to move to a different city, and you need to think about whether that equity and that control piece is going to go with the person if they leave before the company really gets going. So we typically counsel the founders to put in, 4-year vesting is the most common with a 1-year cliff. And that's important because if folks leave and they're not vested, then you can get some of that equity, you can get some of their equity back, which obviously goes to the control going forward. And then I agree with Caroline. We don't see dual class voting at early stages with like super voting for the founders, even though there are some founders that would like it and think they might want to put it in now to kind of preserve it down the line. Usually the institutional investors are very strongly resistant to that, and they won't, if that's been implemented, they'll tell them to revise it and amend the documents. And so we just don't see it that often. One more point. So Caroline mentioned protective provision. So the founders is the important part of the control at the beginning is who controls really the stockholder vote and the board of directors. But when institutional investors come in, even if they don't control the board, which is common at like the Series A and even the Series B stage, they will almost always have these protective provisions, which are vetoes if they want to do certain things like sell the company, or so the investors exercise control that way on kind of significant decisions, whether or not they control the board.
That's interesting. John Coates of Harvard Law School wrote an interesting paper, it's probably 10 years ago now, that found significant practice differences between law firms in the East Coast and in Silicon Valley in terms of what they recommended both startups and IPO firms do on issues like going public with a poison pill or going public with staggered boards and so on. In your experience, are there emerging differences on how control's being allocated, founder control versus investor control, between the emerging community here in Silicon Beach and the obviously much more established community in Silicon Valley?
I don't see much difference, other than the few exceptions I mentioned before, where you have the serial founder who has some leverage and maybe there might be more of those up in Silicon Valley, but as a rule, they tend to be the same terms.
Yeah, I agree. I think the terms are largely the same. There are some differences between the East Coast terms and the West Coast terms, I would say, but I think our terms here largely follow the Silicon Valley terms, and that's because really there's a lot of Silicon Valley investors that are investing here. Maybe one of the biggest differences is just around the East Coast terms tend to be a little bit more, the investors tend to have a little bit more control, whether that's because the board of directors control typically follows ownership. So if the investors control, let's say 40% of the stock, they would usually have 2 of the 5 seats or 3 of the 7 seats. So it typically tracks that. But East Coast terms generally have more protective provisions, and they might, instead of having 3 founders and 2 investors, if the investors have 40% of the stock, they might have 2 founders, 2 investors, and 1 independent. So having a more balanced board.
That's interesting. How, as your startup clients get towards the IPO stage, are you noticing, does everybody want to perpetuate founder control? Are there certain industry sectors where founder control seems to be more important? And sort of when does that issue tend to arise as you near the IPO stage, assuming your client's going to go that route?
Yeah, I think it surfaces around the Series B, Series C stage, and some of it, whether the investors take control of the board, depends on what percentage of the company they control. If Caroline mentioned, if you do have kind of a rock star founder, if Elon Musk is founding a new company, which he might do, given the number of companies he works with, or Mark Zuckerberg's going to start a new company, they would tend to probably get unusually protective, positions compared to the average. But in my experience, it's right around the time the investors gain control of the fully diluted stock that they would gain control of the board.
I'd agree with that. We often tell our founders that they should expect to lose the majority of the stock vote sometime around the B and C inflection point, so that after the A, you expect they still hold more than the majority, but B and C starts to shift more toward investor ownership. One more point we sometimes see, and this gets to a point often when they're getting later stage and thinking about exit, sometimes companies will bring in, replace the CEO with a professional manager and move the CEO to a consultant role. There are some provisions we see in the agreements, such as maybe a drag-along, that investors will often insist they're fine with the founders having a control or a blocking right, so long as they're still involved with the company. But if they ever leave, Chris mentioned before, someone might want to move to a different state or start something new, or maybe there's a dispute, then they oftentimes will lose that right, lose that control.
Interesting. Well, let's turn then to the IPO stage. And I was involved many years ago in the litigation over SEC Rule 19C4, which was the SEC's attempt to regulate dual-class stock back in the 90s, or the 80s really, and was one of my last moments in practice was writing the Business Roundtable brief in their suit against the SEC. And after 19C4 passed and was struck down rather, and we got the stock exchange listing standards that permitted IPO dual classes and grandfathered in a few older firms like Ford and Hershey and so forth. Dual class stocks seem to go away for a long time. And it's come back, obviously, and most significantly in the tech sector with high-profile firms like Google and Facebook and so forth. And I'd like the panelists to address the question of why is it that we see dual-class stock, particularly in the tech sector, and why is it that we've seen it reemerge in that sector in recent years? I guess to put it another way, is there something exceptional about tech firms that founders want control in a way that perhaps they don't in some other industries? And I'd throw this first to David and Ken, and then Caroline and Christopher can weigh in.
I think there is a recognition in the tech sector especially that today's public capital markets are broken. And I don't think you can really understand founder control in the public capital markets until you understand and see that the breakdown in today's public capital markets. Founder control in dual class stock is simply a reaction to the notion that 100% of consideration of what's to happen in the company in today's public capital market should be held in the hands of equity holders. And there is a view that that doesn't work, and that particularly doesn't work in who today's equity holders are, right? So you have in today's markets, the three largest institutional investors own, the numbers own about 40% of stock in 88% of the S&P 500. So that's just BlackRock, Vanguard, and State Street own 40% of the stock in the S&P 500. And for founders trying to take the company public and trying to deal with what's going to happen in their company stock, that notion that they're going to be controlled by a handful of large institutional investors who are very reactive oftentimes to short-term holders, activist investors, is just something they're not interested in. When you couple that with the vast amounts of capital that are available for private investment, we talked at the last panel, mentioned SoftBank, and there's just huge amounts of capital that's available for private companies. Companies today, in the tech sector especially, are not interested in going public unless they can have a greater say over who's going to be part of their ownership and who's going to be making decisions. And that's led to dual class stock, it's led to people looking at 10-year voting, it's led to the long-term stock exchange being considered as an alternative. It's led to a wide variety, a number of things to be looked at, but they're all in response to this notion that the public capital markets today are fundamentally broken. And I think that's where you need to start from.
Okay. So just to respond a little bit, and thanks for having me. Thanks, Jim, for the invitation. First, I don't really buy it that the tech companies are different because tech entrepreneurs understand that capital markets are broken, or the public equity market is broken, and smart entrepreneurs who are not in tech don't understand that. I don't quite get that. Why that would be. I mean, I think there may be, and I don't really know the answer to your question. I mean, clearly there are a significant number of companies that go dual class, although it is a minority. Last few years, it's been around 15% of U.S.-based IPOs, ignoring SPACs and master limited partnerships and so on. About 15%, or even less, are going public with dual class. Now, the biggest ones have been dual class, or a disproportionate amount. So last year, the two biggest IPOs were Snap which is a classic tech company, and Altice USA, which is a U.S. affiliate of a Belgian company that essentially is Cablevision, which was dual class before. They have a worse form of dual class than Cablevision had. But anyway, those were the two. So 50% of market cap of the firms last year that went public are dual class. But it does tend to be concentrated in tech. I don't know why it's different other than culture and the legal and investment banking advice, as opposed to other entrepreneurial companies. Now, another big IPO last year was ADT, the security company that was going public again. And that's an established company that's very different. And so that's in a different class, which I understand. But the second thing I do have to say, the BlackRock and Vanguard and State Street aren't that big yet. They tend to have something like 8%, 6%, and 4% of the holdings of a lot of companies. They may get that big, and there are a lot of issues involved if they get that big. And I should say all three are associate members of my organization, so I may be biased on this, but I don't think they quite have that influence. And in any case, they're very judicious in their use of influence. They don't tend to throw their weight around. I don't think anybody, even if they're not passive in a colloquial sense that we're used to, they're not activist shareholders, and they tend to side with managements when there are proxy fights. And even now, there aren't all that many proxy fights. So I don't have an answer to your question because I don't really understand why people are that concerned.
Well, then, can I just follow up briefly, Ken, and ask you to address? It does seem like at least some of your members are vocally opposed to dual class stock. But as to the 15% you mentioned, they also seem to line up to buy those shares. What's driving them? Why aren't they simply saying, okay, Facebook or Google or what have you, if you go public with dual class stock, nobody in the CII will buy your shares? Yeah,
that's a great question. At IPO, we have some members who do play in the IPO area, which is a particular kind of market. Most of our Council of Institutional Investors core membership are asset owners, particularly pension funds, and particularly public pension funds. We have associate members who are non-voting, so we have our own dual class structure, who participate a lot and actually have a lot of governance expertise and so on at this point. But and we have a good number of overseas members who actually are the most vociferous on this. I'll tell you, asset managers overseas are the members of our organization are the ones I hear from most strongly. Most of our members are not participating in IPOs. They will buy when it's in some broad-based index. They want to own a broad-based index. There's been a lot of debate over the last year and differences of opinion about exactly how those indices will work. But they see themselves getting saddled with something that long-term is dysfunctional from their standpoint through IPO processes that they're not really part of. And so if CI members declared a strike and that they would not own no company that went public with dual class, that probably would have a significant impact. The fact that the S&P is going to exclude dual class may have some impact, I imagine, which is, you could argue, kind of a ramification of that dynamic. It might be better, though, if there were some reasonable regulations, and because of the lawsuit you were involved in really at the stock exchanges, which many of our members regard as hopeless, rather than by the SEC, but at least some reasonable regulations such as time-based sunsets, which we're seeing a number of these companies adopt. There were 6 dual-class IPOs last year that went public with sunsets, and they range from 5 to 17 years. And that's a solution for a lot of reasons, which I can get into. But I think if they were willing to step up, the stock exchanges were willing to step up and enforce that kind of rule, I think you'd have less concern.
There's a lot there that I'd love to unpack, and in particular come back to the question of the impact that we'll have with the indices kicking dual-class stock out of the indices. which I think is a very interesting and potentially very troubling development. But I can tell David's been eager to jump in here.
I don't know, Ken and I go through this a lot, and I'm fortunate enough to have Ken to my right frequently on these topics.
Yeah, we really didn't line that up.
No, but just going back to the capital markets for a second, we have half the number of public companies today, approximately, that we had in the late 90s, early 2000. So the Wilshire 5000 is really today the Wilshire 3500, because there's just not 5,000 companies there that are in it. We have about 4,500 public companies, and that is a sign. Particularly gone are small public companies. The typical size of an IPO when I started practicing was couple of $100 million IPO. It was very common. I see Joel nodding his head there. He remembers that too. We all, back in the late 80s, early 90s, that was a good size IPO. Today, if you want to go public, you're going to go public with $1 billion market cap at a minimum, because there's just not enough infrastructure to support you don't get viewed by the investment banks, there's not enough following. The large institutional investors won't buy in to companies that are that size. So we've got a whole range of problems in our capital markets. And then when you add on to that half the people in this country don't own any stock, right? Have no investment, 401k, no nothing, neither directly or indirectly, and have nothing in the stock market. And the number of the wealth impact in the stock market is escalated even greater than wealth in this country generally. So that the top 1% have an overwhelming number of control over who owns the stock market. And what it does is it creates a significant impact if you're a founder of a company and you want to run it a certain way. And so, if you're concerned about how your employees are, if you're concerned about how the technology works, if you're concerned about trying to build a bigger enterprise, the notion that you should just focus entirely on shareholder return is something that I think technology people wonder about. And I think it's also being questioned more broadly. And I think it's being questioned more broadly across the globe. Hong Kong has opened up a new effort to try and allow dual-class listings, partly in response to Alibaba listing in New York. Singapore is opening up its markets to dual-class listings. So you're seeing, arguably, a trend to look at these issues more globally at the same time you're seeing it in the United States.
Caroline, Christopher, would you like to weigh in on the question of why it is that investors are willing to buy shares of dual-class companies?
Well, my thought, the tech companies usually, the early stage investors are really betting on the vision of the entrepreneurs, they're betting on the team. And I think that logic applies in the later stage as well. Like if you bought into the Snap IPO, I think to some extent you're betting on the leadership of Evan and Bobby to continue to grow the company. And so I think that, in my mind, that's one reason why in tech the investors seem probably more willing to bet on the leadership, because they have a vision for a disruptive product, and they've shown in the past they're going to execute. If they're going public, they've executed to that point, and so they're kind of betting on them to continue to build an even more disruptive global enterprise. So that might be different than some other industries. I know from the entrepreneur's perspective, they're not only focused on building a great company, but they're focused on kind of making a difference in the world, a lot of them, and so having that control is incredibly important to them.
Yeah, absolutely. We hear from investors all the time that a very close second behind looking at the business is looking at the team when they're investing, and I think these people are really just looking at trusting in the vision of the founders.
So what it's really about is you've got somebody like a Mark Zuckerberg who has survived a very Darwinian competitive process to get to the IPO stage, and investors are willing to bet that he or she can continue to survive in an even harsher competitive environment, I suppose.
Yeah, and they're confident that the decisions that the founders will make are going to be the right decisions because maybe they know the industry better than they do.
Yeah, I'd say most companies don't go public with dual class. I think that most cases there's an advice that there will be a discount in all likelihood. It's hard to quantify.
Sure.
And if you look at the biotech sector, they don't mostly go public with dual class.
Yeah. Let me follow that up though. The ones that do go public with dual class, one of the things that's puzzled me about this whole revival of dual class stock is what are the founders afraid of that makes dual class stock more attractive than, say, going public with a classified board and a poison pill in place? And David was talking about activist investors, and that's certainly an issue that I've written a lot about. But, you know, companies cave to Lucian Bebchuk's campaign against staggered boards, where they could have shown, you know, a tiny bit of spine and said, go back to Harvard.
We caved because of this man.
And he did have a little bit to do with it. And as I read the Delaware tea leaves, you know, the third point decision, I think Delaware, when push comes to shove, is going to uphold activist pills. You know, you could have a staggered board and an activist pill, and that's at least as good a protection as dual class stock. And it doesn't get you into these controversies that I want to talk about in a few minutes, like stock market indice, membership, and so forth. So why aren't they doing that?
So I should let David answer, but I think actually a lot of companies are doing exactly that. Most companies that IPO do IPO with classified boards. And the poison pill, whether having...
Is that as true as it used to be, though? I mean, I know
think so.
I know Lucian got a lot of established classified boards de-staggered. But in the IPO stage, is it still true?
We can go run the stats, but I think it's still true.
I think you're right. I think, you know, you go public with a staggered board and then you de-stagger 5 years out.
Which you can make an argument. There's a new study by Martin Kramers and some others, Martin's at Notre Dame, that suggests that initially dual-class companies, and it's based on another study, that initially companies with a lot of protections outperform. Longer term, they underperform, and the lines cross about 6 to 9 years out. So that would suggest it may make sense to go public with a classified board, understanding that at some point down the line, a different shareholder base at a more mature company is going to remove it.
Well, this is an interesting question, too, that got a little bit of traction. Newly appointed SEC Commissioner Robert Jackson, his first speech was actually about perpetual dual-class stock and suggesting that for exactly those reasons that we might want to see founders be able to maintain control for a period after they go public and then have the dual-class stock
But I don't think, I mean, to be clear,
disappear.
A pill and a staggered board isn't even close to what dual class stock provides. I mean, there's a fundamental difference, right? If you have a pill and a staggered board and you're able to keep control over 2 years through 2 different proxy fights, or someone comes on, for those of you who have been involved in a proxy contest, if you've sat on a public company board and you've faced an activist, your business and the way you operate the company changes fundamentally, even if you are successful in prevailing in the proxy contest. Indeed, even during the proxy contest, before there's any results in, you know, you're spending a ton of time focused, talking with people like me, and who wants to do that, and focused on trying to figure out how to make short-term improvements in the company's financial position so that you can beat back the activist. And you know, even if you're successful in one, or you know, you put on, typically activist contests settle, and so somebody comes on the board, the change in the business becomes quite dramatic. So you know, it's a very different dynamic.
I partially agree with David, but I do think a classified board is a very potent takeover defense, and in fact, there are a few battles won, and in those cases, I would argue pretty much the companies are basket cases. I mean, the problem with the perception that management needs to keep going is that, and most often where they really are thrown out, it's because there really is a problem. They're doing a terrible job. So.
Does the I want to address, at least briefly before we open it to questions from the audience, Ken raises, I think, a very interesting point, which is the move towards the stock indice providers kicking dual-class companies out of the indexes. And that was an aspect of Commissioner Jackson's speech in which he noted that increasingly middle America doesn't, as we all know, doesn't own stock directly, but they own stock through the kind of companies and pension funds and so forth that Ken has as his members and associate members and so on. And most, well, I don't know most, but many of those funds are index funds. And if the indices are not going to include dual-class companies, then in effect we're squeezing middle America out of being able to invest in those companies. And whether the SEC ought to consider regulatory intervention so that the indices are looking at, the top 500 companies, the top 5,000 companies, without regard to governance structures, or whether the indices ought to be allowed to take this into account. And I guess what I'd like the panelists, and we can start down on the far end, to address is whether they have views on that and whether they think this trend, if it becomes a significant trend, is going to affect company exit decisions. Are we going to exit via the IPO? Are we going to look for some sort of merger? How is this going to have an impact on what you do, I guess, is the question. And I'll start with Christopher, perhaps.
Yeah, I mean, as David pointed out, there's a lot fewer IPOs. I think most of our clients are really not even focused on an IPO. They pretty much assume from the beginning that they're going to exit via, an M&A deal. So that's by far the majority of the exit. So I think the legal framework that we have and some of the changes that have happened, after the .com bubble burst and in the financial crisis, all of that cumulatively, I think, has had an effect of there just not being as many IPOs. So in my experience, in our practice, most of our clients are like Ring, for example. They could have done an IPO, but they chose to sell, or or it's not done yet, but to Amazon. That's a good example of one where they've chosen that exit path. So I think it is, what we're seeing is a lot more M&A compared to capital markets deals.
100% agree. It's rare that we see a client that plans to IPO, and even rarer to see one actually do it. And I don't expect that changes like this will permeate down to the governance structures we put in place at the Series A, B, or even founding stage of the companies.
So when your clients are exiting via the M&A structure, are they being acquired by public firms, or are they being acquired by private equity? Both? Is there a trend in that area?
I mean, a lot of time it's strategics in tech. The strategics buy a lot of companies. That's common. But we're also seeing private equity firms that are increasingly focused on tech. There's some large ones out there.
I think this would be like SoftBank's investment in Uber.
Yeah, exactly. Yeah, and some of them make kind of minority deals like that, like growth equity deals, and some of them are just buying the whole company.
Interesting. David?
Yeah, no, I think Christopher and Caroline are 100% right. And it was said on the last panel, it used to be 50-50 IPO to M&A, and now it's 90-10. And the large companies that do go in favor of M&A, and the large companies that do go public now, the unicorns that choose to go public, the last thing they're really concerned about is their place in a few years in an index. So the notion that an index is not going to include them in their fund is just, having advised several of these companies as they're considering it over the last 18 months, it doesn't even come up on the radar
So they're
screen.
not thinking long term?
They're not they don't care, they don't want to be in the index because they view the index probably as, again, the investors they want are the investors who have disappeared in the market. Steve, your mention of Middle America and Commissioner Jackson's, of individual investors who buy companies, who know the company, who think about the company, and who care about it, and they're going to be in there for a long time. Now, those investors have disappeared from the market, but that is ideally who these people want as their investors. And so the notion that they're not going to be carried in an index fund which is going to trade or not trade and has no idea who they're voting for, and when proxy season comes around, listens to ISS or has a handful of people in shop to decide based on various numerical metrics, is just not something they're particularly interested in.
Okay, just a couple comments. Actually, the bigger ones don't much listen to ISS, but anyway, aside from that, on the IPO debate, is it a problem that we have fewer IPOs? So my members have divided views on that. Many of them, all the biggest ones, have private equity programs. They're invested in private companies, and they feel like that's fine. The company doesn't need to go public. And of course, their beneficiaries are middle class, but pension funds are smaller than they were. The other view is, okay, but at some stage, I want the company to go public because it's more liquid, it's more transparent, it's cheaper. It's just a bit better if they go public. So we have some big pension funds that have very successful private equity programs that would agree there's a problem. On the index providers, it's as I said earlier, probably a second best solution in some ways to stock exchanges doing more. But I also the index providers have in some ways done less than I think the noise out there indicates. It's a very interesting business, and they're positioning against each other and positioning their own products. So the S&P indices, the 500 and the mid cap and the small cap, have always had a lot of qualitative criteria. They don't portray themselves as being total market indices. So S&P decided that's the appropriate place to say no dual class. They had a lot of a discussion about other alternatives and decided everything was too complicated, and they're just saying going forward no dual class. Whereas what FTSE Russell said was you have to have at least 5% of your votes in public hands, so that there's a little bit of public presence, a little bit of the aspect of being public equity. They may increase that. They got comments from investors that suggested, by and large, suggested more than that, so they're going to revisit it each year, but it's fairly limited. MSCI just basically called a halt last year. That's the other big index firm, and they just launched a very complicated proposal to essentially underweight dual class stocks, and we'll see where it goes. It would cut the weight of Google, for example, approximately in half in their index. Now, I suspect they'll obviously get pushback from companies. They don't care about that, but they will get significant pushback from investors on that. And so we'll see where they end up.
Yeah.
One thing to add about this is all so new that the economic impacts of all of this is really completely unknown. One of the things that's interesting, I don't know if you saw it, Google a few years ago adopted non-voting stock in addition to its low-vote stock. So Google has three classes of stock: high-vote stock that's owned by the founders, single-vote shares that you can buy on the market and that they sold at the IPO, and zero-vote shares that you can also buy on the market. When Google did that, there was the lawsuit, and there was a big question as to whether the zero-vote stock would trade at a discount and how much of a discount it would trade at compared to the single-vote stock. Lately, the single-vote stock has traded at a discount to the zero-vote stock.
Is that true? Because for a long time it had been 2% discount,
Correct.
Fairly consistently.
Correct, exactly. And that's,
So why is it reversed? And they
we don't
tried
know.
to reverse the tickers to fool the market, which I didn't quite get that.
So we represented Google, and I represented Google in that. And the settlement was we had to pay a true up for the difference between the single vote shares and the zero vote shares, and Google paid that in stock, and fine. And so that's why I happened to notice it was just very recently that they changed around.
Okay.
But all of this is the economic impact of dual class stock. The number of companies, as Ken rightly notes, very small number of companies, unicorns almost by definition, right? there's a few different flavors of it. Some have succeeded wildly, Facebook and Google. Some have failed miserably. And that's pretty common in the public markets generally, too. There's plenty of examples of companies that have done wonders with single-class stock, some that have failed miserably with it.
Well, let's open it to the floor then for questions. And as my colleague and dear friend Iman said, I am a professor and I am prepared to cold call on people if that's necessary. Anyone have questions for our panelists? Yes, sir.
So maybe going back to smaller companies, but it was true of Uber. Have you been involved in situations where founders are ousted at some point?
Are you directing that at all of them or any of them, or?
Yeah, I'm just curious because the title of the panel is investor control, and the founder control. The founder may have control, but the founder or the founder's board may decide that the founder shouldn't have control anymore because the business isn't going so well.
I didn't particularly address that to Christopher and Caroline at first. As a point of personal privilege, I had a couple of law students who back in 1998 came to me and said, we have a business plan for a startup. Could we do it as a semester research paper with you and get your feedback? And I said, sure. And they did their business plan. They started their business. It became reasonably successful. The three law students were the CEO, CFO, and COO until they brought in a real venture capitalist. And 6 months later, they were consultants. So I'd be curious to know what your experience has been in that regard.
Yeah, it comes up all the time. Founders get ousted regularly. It's something the founders are worried about. Whether the investors can do it depends on if they control the board, if they control the fully diluted stock. My experience kind of happens one of a few ways. Either they have the control and they can kind of fire the founder and remove them. Maybe the founder stays on the board but is removed from the day-to-day, kind of like the former CEO of Uber. I think he's still on the board there. Maybe the company's running out of money and there's a disagreement on how the company ought to be run, so the investors can leverage that. Even if they don't control the board or the vote, they can leverage the fact that they need to raise money. Maybe they have a protective provision so they can block the new round, and they can leverage that for some changes. Or they may threaten litigation, for some reason, and try to leverage that into coming to a resolution. So that it happens all the time. As the company's counsel, we don't represent the founders, so our job is to kind of counsel the board of directors through those issues.
Yeah, it definitely happens all the time, and more often than not, people will try and make it amicable. So they'll work on, as opposed to a forced termination or firing, they'll work on a transition to a consultant role, if that's amenable to the founder. And that's also where the issues that Chris and I mentioned earlier, things like founder vesting and whether there are provisions in their agreements that are tied to their providing services to the company become very important. It's one thing if they're serving as CEO, it's another thing they still hold their stock, then they control the vote. So paying attention to what rights they have as a stockholder and whether those are tied to if they're still serving as CEO are really important in those cases.
Are there contractual mechanisms for a founder to at least ask at the outset? Let's say you've got, the hotshot entrepreneur has been written up in 25, different places, and she says, I'm not going to be ousted. Draft up a set of documents that ensures that my investors can't do what you're describing. Do you ever see that? And if so, what kind of provisions might you use in that situation?
I don't see some sort of guarantee for a founder to stay on as CEO. Once in a while they will, if they're a hotshot, for instance, maybe negotiate an employment agreement that gives them some sort of severance if they are terminated, but their way to control their staying on as CEO tends to be, as Chris mentioned, if they control the board. So once the investors have control of the board, or perhaps the investors plus an independent director, then the founder's kind of at the mercy of the board for their position.
All right. There were some more questions over here. Yes, Joe, sir.
This is sort of directed to David and Ken. I also was around in the days when a company with $30 million in revenue could do a $10 million IPO, and it was kind of frequent. And now the reality is that only a very small single-digit venture-backed companies can get the choice whether they want to go sale or IPO. You kind of politely described that, David, as the infrastructure required, but the reality is we're regulated out of that market. And so is that a good thing or a bad thing?
Well,
By placing aside, I think that's kind of part of the fuel that's driving this whole ICO craze right now, is because companies that are much slower on the scale can achieve some liquidity through, or perceive they can achieve some liquidity through an ICO.
So, I'm going to put the value judgment aside and tell you what I think it's done is it's changed what an IPO is for. So IPOs used to be done when they were that type of company for capital raise, okay? They are not usually done for capital raising purposes anymore. The money Google raised in its IPO is still sitting in its bank. Same with Facebook. It's not usually done. Big companies that are going public, big tech companies, typically are not raising money for additional capital. If they needed additional capital, Uber raises it privately. They're going public for other reasons. Employees want to get liquidity, perhaps, or they want to have a greater currency to do acquisitions sometimes. But it's not in the traditional days of when they needed additional capital, because the capital that they needed is now, if you're a private company, is readily available.
Which suggests it's not really a problem. The capital is there, and so they don't need to go public for that. And in addition, as the earlier panel pointed out, there are more companies that really are pretty low capital intensity, so they don't need that much capital. I'm not sure it's a problem. I also do think there were too many IPOs in the 1990s that bombed and flamed out, and I don't think anybody particularly benefited from that except transaction attorneys and others.
You say that as though it were a problem. Speaking as someone who educates transaction attorneys. More questions? Yes, sir.
I'd like to ask about governance in the pre-IPO stage, and this is the dual class between preferred and common. There was a decision out of Delaware Chancery Court last year which sort of said that the investor of majority board had reached fiduciary duty by in fact determining to be its preferred stock. And I'm wondering if you guys have any views on that issue, governance between the preferred and the common.
So that was my case too. Oak Hill versus ODN. We represent, Oak Hill was a private equity investor, and there's several big cases in Delaware. Another one that I did was Trados, which said that the only obligations of a board of directors is to the common stock, not to the preferred. And that is, as Stephen knows, a big issue that is in Delaware. My problem with those decisions is I don't think they look at the economic realities of how private companies work, and so I don't think they're logically hold together. But having been before the judges and will be before them again on that, unless they're in front of me, I'm going to hold back my full criticism of them, at which point I would tell them what I think.
Those decisions, and I agree with David. I've written several times about Trados and some of these other decisions, and there's a problem and a lesson. The problem is that the Delaware courts are taking law that was really designed to deal with the sort of classic, utility company that has preferred stock for, people that want to clip coupons and have a steady stream of income, and trying to apply it to venture capital situations, which are economically very different. I think the lesson has been, though, that the Delaware courts will respect contracting, and if you're creating preferred in a startup situation, and I'd ask Caroline and Christopher if they disagree with this, but I think the Delaware courts will respect what you do contractually, as long as it's very clear what you're doing contractually. But if you don't spell it out, then you get into the whole Trados question of whether, this is a preference, which is contractor, whether it's not a preference, which is fiduciary duties. I think the lesson is be very, very clear about what rights you're giving the preferred. But do you guys disagree?
No, don't disagree at all. I mean, sometimes founders ask, why do we have stacks of hundreds of pages of documents? And the reason is we have to be very, very clear about what specific rights the preferred are getting relative to the common.
Yeah. Other questions? Yes.
This may be sort of a follow-up of my misunderstanding of what you just talked about. With the board that's been elected under the dual class, is there potential of having different fiduciary duties or fiduciary risks?
No, so all of the board members have the same fiduciary obligations to, as currently described by Delaware, to the shareholders, to the corporation and its shareholders. The difference is who can remove and who can select directors. And so directors of a dual-class company can feel constrained by the fact that a small or single group of shareholders can replace them. It's something that happens in private companies all the time. And again, when you're negotiating your Series A or Series B investment, one of the big negotiations is who gets board seats and under what terms. In a private company, it's usually not such a negotiation, but in a public company. But when you have dual-class stock, those issues can really come to the fore.
But David, Charles Elson at Delaware is arguing that, say, the board of SNAP may have more vulnerability to lawsuits or will down the road. The argument being that it's harder for them to clearly indicate independence of a committee, even though they have independent directors, independent of the founders, if there are controversies over the founders. And so what do you make? Is that, I don't have any view on it. I'm just wondering if that's...
Yeah, so I have a view and a bias. Okay. So it is the view is that it is always a challenge when you have a board that is with a controlling shareholder to show that the directors are independent. And I have a bias that the Delaware courts have shown to, I think, particularly Silicon Valley, and I soon suspect it'll be Silicon Beach as well, that the directors who, if you're located in a geographical region where there's a lot of links between directors and the founders, that you're much more likely to be found as an interested director than if, for example, you're a Harvard law professor and you're sitting on a board of a biotech company in Cambridge. You're less likely to be considered.
As long as you're not associated with a major university in the area.
Right. There's the question you raised, though, I think is a very interesting one, and one that we actually talked about last semester in my business associations class, because in that course there were three cases that sort of raised those issues. There was an old New York case involving related party transaction involving a director called Bear versus Moran, where one of the complaints was that the decision was ultra-virus because there was never a formal board of directors resolution to approve this transaction. And the court sort of said, well, and of course this was back in the day when you didn't have independent directors. All the directors were employees of the company. They were all sort of around the building. They all sort of talked to each other all the time. And it would have been better to have a formal meeting, but under the circumstances, they treated that as approval. It's Bear, B-A-Y-E-R, versus Moran, B-E-R-A-N. And it's a New York case from the late 40s. There's another case, the Delaware Corporate Opportunities case from, I think, the late 90s, Bras versus CIS, where, again, the Delaware Supreme Court said, would it have been better if the director had presented this corporate opportunity to the board and had the board formally reject it? Yes, but, again, this was a smaller company. Everybody sort of knew each other. He ran it by the key people. They all said fine. And so the Delaware court said, we're not going to throw it out for that reason. But then you get the Zuckerberg case, right? The recent Zuckerberg case on director compensation, where the Delaware Supreme Court came down hard on the fact that they didn't use the correct formal processes to get Zuckerberg's approval. And the court made it quite clear, I think, that whatever leeway sort of traditional firms are going to get going forward, that where you have dual class stock and you've got the controlling shareholder, you're going to have serious attention to formalities. If you want to have the controlling shareholder, for example, signing off on a director compensation plan, you're going to have to comply fully with the written consent statute, right? That all of your I's must be dotted and T's must be crossed, seems to me to be an emergent principle, and seems to me to be a perfectly sensible principle. I don't think the fact that Zuckerberg controls 60% of the stock, that you ought to be able to just say, will you sign off on the director comp plan, and have them go sure, and have that be the decision. That's, at least you can hold them to using the formalities to make the process more transparent and hopefully get a little better decision making. Joel?
I have a question about these sunset clauses and how prevalent they are, and in fact whether founders are accepting them, or is the fact of the matter is that they're going to have to be imposed from some external source if we're going to have sunset clauses. Because it seems to me that one of the dangers of dual-class stock is that over time you may end up having an irrational, vindictive founder who does not have the best interest of shareholders.
Donald Trump.
So
there's a whole list.
Now, let's not get political.
there were 6 last year, which is the most there have been with time-based sunsets. So different kinds of sunsets. We're more interested in the time-based ones, partly because they're very simple. In prospectus language, it's among the most simple language and straightforward. And some companies they've come and gone, and the shares have collapsed into 1 share, 1 vote. So there's definitely interest. It is, what was it, maybe a quarter of the dual class IPOs last year. So that's more, but of course not the biggest ones. So.
Yeah, so first, at least most of the technology IPOs have some sort of sunset clause. Usually it's for when the economic ownership of the founders changes. So when the economic ownership is reduced to below a certain stake, then the 2 classes of stock will merge into the dual class stock will disappear.
But the controlling shareholder has lowered that sometimes later. Ford family has lowered 4 or 5 times. I mean, that's a 40%. But
correct, the Ford family, but right, that's not a technology company, and there's, right, so the other part of it is, again, a lot of this is looked upon as a sin of technology companies. It actually, as Steve mentioned, it goes back a long time, and goes back to the Dodge brothers in 1925 and the Ford family. But for tech companies, you do see, I think there is a lot of thought being given to sunset clauses, how they work, when they should work. Some do, as Ken mentioned, have time-based, 5, 10, 15 years. Others have stock ownership-based. This is also still so relatively new. When you think that Google was really the first one in 2005, and then again it sat quietly for another 5 to 7 years until really 2012. So I don't want to deny the push and deny the impact and all of that stuff, but it is, we're talking about a handful of companies in the last 5 or 6 years that have really done it.
At the same time, this is not a new problem. I would encourage you to Google at your leisure a wonderful poem from the 1920s on waiting in vain for the new masses to condemn non-voting stock, which was a commentary on that debate. I think we're pretty much at the end of our time. I'd like to very much thank all of our panelists, Christopher, Caroline, David, and Ken, for, I think, very insightful and thoughtful comments. And I'd like to thank those of you who asked questions for, I think, were some great questions. And I hope that the rest of the day goes well, and thank you all very much.
Thank you.